Well, good morning or afternoon, everyone, and welcome once again to another in the long history of CSPEN webinars. We'll be starting here in about another 5 to 6 minutes. Congratulations and thank you to the over 100 of you that are already signed in out of the over 290 to 300 individuals we have registered for today's webinar. We'll start promptly at 2 p.m. Eastern Time with a couple of the reminders of the do's and don'ts and a summary and recap of the first half of the year. We'll get started momentarily. Well, good morning or afternoon once again. We're depending on which coast you're on. We're about 2 to 3 minutes away from the start of today's CSPEN webinar, a federal legislative and regulatory update, in which we hope to summarize the first half of 2020, and oh, what a year it has been. We'll get started here in another 2 minutes, so welcome to all of those of you who have already joined on. We're waiting for some of your colleagues and our colleagues to join us. We have about 300 participants registered for today's webinar, and many of them are filing in now. We'll start in another 2 minutes. Well, good morning or afternoon, and welcome everybody to today's CSPEN webinar, a federal legislative and regulatory update and a status report on the first half of 2020. As many of you know, we always here at CSPEN record our presentations so that you have the opportunity through our archive on our website to play them back and review the slides as well as the presentation at your leisure. So we welcome you to do so. A couple of the other reminders: we do have the question and answer capability on the right-hand side of your screen or at the top of your screen, depending on how you're reviewing your materials. We encourage you to use that in order to provide the opportunity for Q&A. We will attempt to go through a Q&A at the end of today's presentation, although we do have a rather lengthy series of slides that I'm going to try and go through relatively quickly, but informatively, hopefully, with all of you today. We do appreciate all of the participants and the attendees on today's CSPEN webinar. We recognize it's been a couple of weeks since we shared some information with you. Part of that was because there were kind of a little bit of a lull, but things have picked back up again, both on Capitol Hill, as well as with regulatory guidance from the Department of Education, and some new information that came out as well from the Trump administration and the National Workforce Policy Advisory Board, all of which we'll cover on today's webinar. So without further ado, Here is today's agenda. As I said, we'll be having a mid-year review and a look back over the first 6 months of 2020. And oh, what a year it's been. Certainly between the pandemic and all of the frustrations and concerns within our community over police enforcement and areas with regard to our nation as a whole and our belief structures and our treatment of our friends and dear friends and colleagues across the entire spectrum are things that are weighing heavily on certainly my mind, and I'm sure on yours, both from a student perspective and an individual perspective as well. But we will go over today a regulatory update, a legislative update, and as I said, some new information that we strongly encourage you to review with regard to the National Workforce Policy Advisory Board, but I'll get to that in just a little bit. Moving forward, we'll start with a regulatory update. A number of the things that we'll cover today are in fact repeats of information that we provided to you in previous slide presentations, but we did want to make sure that we remind you of these as we get to the middle of the year and also give you some new information and breaking news that you haven't heard yet. With regard to the new regulations scheduled to take effect in literally just 2 days, we did have several webinars on this in the past, and we encourage you to go back to the CSPEN website and review that information in those webinars. Not only did we provide information on our own, but we have had webinars where we brought major attorneys from across our community to share in the presentation of many of the slides I'm about to go through with you, so that they could give you their perspective and their oversight of how they are seeing and hearing and reviewing this information, interpreting it, and sharing it with their clients. First up, gainful employment, one that's not new to us. We've had the regulations and the final rule for this particular set of regulations for some time now. The good news is that we also have the ability to early implement these regulations. You'll recall that these regulations were scheduled and are scheduled to go into effect on July 1st, but because of the department's proposal to put the regulations forward early and the opportunity to then allow institutions to implement them early, I believe many, if not most of you, have already fully implemented the gainful employment regulations. A couple of the finer points: this is a rescission of the entire rule after many, many years of back and forth with the Obama administration, no less than 3 and 4 versions of gainful employment going through the regulatory process, depending on how you count it and where you start your delineation of the information and the changes that came about. We certainly have gone through many iterations of changes to this particular regulation. The most recent basically wipes clean the entire slate of this information. It removes all requirements and all opportunities for you to post the information in the form of disclosures on your website and elsewhere with regard to your program data related to gainful employment. It also abolishes all of the reporting requirements and the eligibility limitations or restrictions or changes that went along with the prior regulation. As I think you know, but will remind you anyway, if you sought to early implement this provision, all you needed to do in order to bring about that change and make a significant change in all of those reporting requirements and the like was have a note to file that said that you intended to and have in fact implemented the regulations early. That should be dated whenever you made that change and should basically just be maintained on hand as documentation in the event that department officials, other state officials, your creditor, or other individuals seek information on when you decided to incorporate the changes with regard to the gainful employment regulation, especially if you chose to do so before this coming Thursday. Shifting over to borrower defense to repayment and the institutional accountability regulations, a much more detailed and in-depth regulation, nevertheless important, that provided a number of changes in another area of the regulations that have gone through a significant back and forth and a pendulum swing from the left to the right, depending on administrations and the negotiations taking place by the department with the higher education community. As you'll recall, the major portions of this and the finer points from the borrower defense side that deal specifically with the ability for students to seek relief in the event that they feel that they have been defrauded or misled by an institution and seek the ability to have their loans relieved, included a number of changes that are going into effect again on Thursday, 2 days from now. The major provisions there are with regard to the processes under which students can seek to file those claims. The department has made additional changes to the policies and processes regarding the borrower defense regulations and have put those into effect and are working very diligently to go through a backlog of over 7,000 plus individuals who have claims that have not been fully addressed by the department. The department is working very directly and very vigilantly to go through those. There's been a number of court cases that focus on those regulatory changes and those requests for relief from those claimants, many of whom, as you'll recall, come all the way back from Corinthian colleges and ITT some 4, 5, 6 years ago when those circumstances all started. It also requires Secretary authority to take action to collect from the schools any financial amounts that are necessary to protect the federal fiscal interest as a result of borrower defense claims and monies relieved for students. It includes favorable changes with regard to a reversion back to the ability and the opportunity for institutions of higher education to utilize pre-dispute arbitration agreements and class action waivers in the process of their enrollment agreements, limiting and eliminating the ability for class actions to be brought together as claimants and requiring that claims be based on an individual one-by-one basis, and subsequently that review and analysis by the department also be on a one-to-one basis. It does, however, also make sure that this is information that has to be included. These pre-dispute arbitration information and the class action waiver information does need to be a part of entrance counseling. There have been some questions about how to incorporate that information when you use the department's software and their exit and entrance counseling as your means to provide that information to individual students. The best that we all can provide in terms of recommendations there is the ability for you to include information and guidance on these informations and the required disclosures and other information we'll talk about momentarily in your normal information and enrollment package of information that you provide. With regard to the financial responsibility regulations, again, there were significant changes. The new regulatory policies scheduled to go into effect did not abolish the triggers, both the discretionary as well as the mandatory triggers with regard to financial responsibility, but it did make a number of revisions to those changes that CSPEN has highlighted and others have highlighted in a number of webinars specifically on financial responsibility and the issues related to those triggers and what they mean and how they impact and affect your institution and things like composite scores. In the limited time that we have today, we don't have the ability to go fully in depth into those provisions, but I encourage you to look back over prior CSPEN webinars. If you'd like, we can also share with you information on other third-party vendors that are part of our community, attorneys, and many others within our community that have put forward more detailed and granular webinars, and we'll be happy to guide you to where that information can be found for further refreshers on key points with regard to financial responsibility. The effective date and the terms to calculate the composite scores, as I said before, will go into effect in 2 days, and the changes that are regarding those regulations. As well, another major key area where there has been a great deal of discussion is around lease obligations and long-term debt. We have a number of changes with regard to the manner in which and the time frames in which these two major significant changes in the regulation came into effect, and they're predominantly on the long-term debt side as a result of changes that were done to accounting procedures that required changes to the financial responsibility regulations and the ability for the Department of Education to bring their regulations more aligned and more in direct alignment with FASB, which are financial and accounting procedures. With regard to lease obligations, once again, there's been a great deal of discussion and granular follow-up and follow-through on details regarding how lease obligations are to be handled by the institution. The easiest and most simplest way that I can state it, which is probably oversimplifying it, so keep in mind to always go back, as you should with all of this information, to your accountants, to your attorneys, and to your other leaders within your own organization for final decision making. But in short order, the basic deal with the lease obligations are that any lease obligation that you had prior to July 1st can continue on as long as there aren't major changes. At the point at which there may be any significant change to your lease obligations, you must fulfill the new lease obligation requirements in these regulations, and that does require changes in the way in which information is calculated for purposes of your financials and your composite scores and other financial responsibility information. So these new conditions are things that we encourage you to bring forward. The good news here is that both with regard to lease obligations and long-term debt, the period for the transition of these two provisions is over a longer time horizon. So you have the ability, and we strongly encourage you, as the attorneys did on our last call and for a longer discussion on this issue, to make good use of your counsel. Get in contact as you're doing strategic planning with your accountants, as well as with counsel and other individuals, and make this part of your strategic planning so that if you are going to be changing your size and space, your lease obligations will play into that, and the ability for you to project when and what time frames those regulations will be needed for you to start to report to the department will become critical. And similarly with long-term debt, the ability to look at your strategic plan in both the short term and the long term as you look at 3, 5, potentially longer time frames for business development are all things that you should be keeping these two particular provisions in mind as you go forward, as well as many others, but these in particular are things that we encourage you to pay specific attention to, as they are new and they do cause some changes in the process of reporting to the department and how you operate as an institution. Moving on to yet another of the regulatory packages that are coming effective this week, accreditation and state authorization. You'll recall that there has been a major sea change in accreditation based on the negotiated rulemaking and the negotiations that took place at the tail end of 2018 and into 2019, negotiations that resulted in a consensus on a number of different packages and silos of information, the most prominent of which is the accreditation and state authorization. We'll talk a little bit more about distance education and several other packages in the coming attractions portion of this particular webinar, but let's focus right now on the changes that will go into effect in just 2 days and the implications and the impact that it has for you as institutions and your students. There were a significant portion of those regulations that focused on changes to the oversight and the responsibilities of the accrediting bodies, both in terms of their ability to oversee your institutions and the standards with which they use to do so. A great deal, candidly, of flexibility and new latitude has been granted to the accreditors. No more do they have to abide by the same standard necessarily for all institutions under their review. There's flexibility given in order to provide for different standards based on the mission and objectives of the institution. This is seen from many as an opportunity for innovation so that the accreditors can look over the individual entities and really hone in on the mission and goals of that institution, as opposed to keeping it at a 30,000-foot level and trying to apply one standard to all. The downside of that is that you could have areas of focus that are different depending on the type of institution and its mission, and therefore have some instances where there may be more of an apples to oranges comparison between you and maybe your colleagues within the same realm of disciplines, or even within other disciplines as this process starts to unfold. What it also did was bring about a major sea change, as I said before, in the overview and the thought process of accreditation in its entirety. No longer are we thinking of regional and national and programmatic accreditation as separate and distinct forms of accreditation. The lines in particular between regional and national accreditation have become significantly blurred by these new regulations and the processes and the innovative flexibilities that have been provided in them. The department and others within the administration feel that these were needed and necessary to get away from the notion in this day and age, with the advent of distance education, online education, and so many other forms and modalities of assessment, including direct assessment, prior learning experience, and the other, to give entities more opportunity, especially when schools are in recruiting across the entire country, to utilize a more generic set of umbrella of some of the criterion and move away from the notion of regional versus national. There are certainly some distinct changes with regard to some distinct mandates that remain the same, especially when it relates to areas such as licensure and certification that we'll get into in just a little bit, and some new disclosures that are required in efforts and attempts by the department and by the higher ed community to be able to fully provide consumer related information on where you have and where you do not have the ability for licenses and certification requirements that your students and your graduates have to be able to be utilized. There also was a great deal of a new authority and provided to the secretary when it comes to how they assess the quality, not only from a secretarial standpoint, but also from the review and the approval process and recognition process of the National Advisory Committee on Institutional Quality and Integrity. That oversight body, you can always think of it as the accreditors oversee you, the CQ oversees the accreditors and the accrediting bodies, had a significant number of changes in terms of what their roles and responsibilities and how they reflect and assess the accreditors, especially once again with boundaries in terms of region being moved away, but also questions of licensure and certifications and some of the other requirements and new flexibilities that are given, how those are going to be assessed by the body that oversees the accreditors. Moreover, the regulations provided some additional siloing, or I would say even beneficial siloing, of putting the triad back in the order in which it was originally intended, moving a number of the accrediting agency responsibilities and requirements back over under the auspices of the Department of Education or the state organizations that are also part of the triad that review and oversee your institutions. We saw, and I think many that were involved in these negotiations saw that as a relatively good thing, and probably even better than just relatively good, in terms of the opportunities that it provides for accreditors to shift back more to the oversight of curriculum and the bestowing of education on individuals, providing the broader oversight requirements of integrity and the like to fall and reside more with the Department of Education and also the state organizations. Last but certainly not least, there were a number of changes with regard to teach outs and the requirements in the event that institutions unfortunately are potentially at risk or moving towards the ability to close, and the desire to bring about more integrity and more defined policies and procedures for the normal and customary closure or normal and safe closure of an institution. And to build on that, because of circumstances that have arisen not only within the for-profit community and proprietary schools, but also within other sectors of the higher education community, the department felt that the ability to add to the regulatory substance here and provide guardrails for all institutions was a key set of criterion that they have been working towards. And so in these regulations, it brings forth new opportunities and new responsibilities for the accreditors to oversee and provide requirements, if they so choose, on what the roles of an institution are with regard to the development of a teach-out plan, having a teach-out agreement in effect with potentially other institutions, and what they would do to try and make a potential closure as beneficial and as safe to students as possible. Shifting now from the accreditation side to more of a discussion around state authorization and in particular distance education, there was a significant number of changes that this regulatory package also brought forward with regard to distance education, correspondence education, and online education in general. Most notably, the requirements talked about everything from reciprocity agreements under NC SARA to what is regular and substantive interaction between the institution and the individuals delivering the education, the professor, the other individuals with the experience that might be leading the course or the delivery of any particular assignment, and how that interaction is to be considered with regard to the individuals receiving it, i.e. the students on the other end of the virtual education. There are additional discussions around the integrity of the old customary assurances with regard to who is on the other side of the computer, making sure that the work is really being done by those individuals and how that information is able to be judged and assessed in terms of the quality the educational enrichment of the students. The location versus residence was another key issue. What we're talking to and alluding to there, as it kind of basically on its face says, is that there is a distinction that is made between where the student resides and where the student's location is. For purposes of the determination of and utilization of reporting for the Department of Education, it's where the individual is located that becomes so important. Last but certainly not least, as I said before, is the discussion around full disclosures and more in-depth consumer information and disclosures as it relates to programs leading to licensure and certification because of circumstances that have arisen in the past. Again, with all types of institution and all manner of institutions, there's a great deal of discussion around what and how institutions should be providing their potentially enrolled students and all subsequent students that are enrolled in their institution with data and information as it relates to licensure and certifications required to enter or maintain eligibility in the field of study and the occupation or profession that is part of that discipline. With regard to that, the disclosures that are now will become necessary in 2 days are a list of the states in which the institution's program curriculum meets the state educational requirements, a list of all states in which the institution curriculum does not meet those requirements, and also a list of those in which the institution is not aware or not sure one way or the other as to whether or not programs that lead to licensure and certification are acceptable and meet the state standards in those various states. Several questions that have been asked about this particular set of disclosure requirements is where institutions might be able to find information related to how they would go about determining the state educational requirements in each state so that they could then determine whether or not they do or don't meet with those programmatic curriculum requirements. One of the best sources that we can give you to do review is NC SARA, the state reciprocity organization that includes every state except for California and the District of Columbia as part of a national group that has combined all of their standards to basically formulate a overarching set of standards that can be utilized. Obviously, if you can go to SARA, they refer NC SARA, a lot of that information and the ability to drill down is there. If you're in the state of California, unfortunately, things are a little different. You've got to do a lot of the homework on your own there. But in reality, you've got to do a lot of this homework on your own, regardless of what state you're located in. CSPEN, as well as a number of the other trade associations and other groups, NASFA and the like, are working towards trying to develop some of the additional information that might be helpful in this capacity as you move towards putting forward this disclosure information. So we encourage you, if you haven't looked at NASFA's website, they've got a pretty good encapsulation of what to report here, as well as with the other disclosures I'm about to go through, and some recommendations on resources and tools you might be able to use. The other disclosures, and there are many that are scheduled to go into effect, include issues related to transfer of credit policies, graduation and placement information, also information on some of the routine and rote types of information for the consumer that you all have been doing since time immemorial and the Earth's crust cooled, but pending regulatory actions that could adversely impact the students as well are all part of the information that you are now going to be required to put forward. With regard to transfer of credit, this is one that I think is going to be very interesting to watch over time and see how it evolves, because it deals with a number of issues that have been problematic for our students as over the years, as the receiving institution has always and still continues to be the responsible party for determining what credits will be accepted as an individual attempts to transfer and utilize their prior education to not have to repeat new educational requirements. In the past, a lot of that has been specifically at the regional level or more traditional state colleges and universities and other institutions, hidden behind a veil or a curtain, and as we all know, rather subjective in its nature, basically in many instances precluding the ability for recognition of credits received at our institutions from being eligible to be able to transfer to other institutions of higher education. These regulatory requirements would not preclude institutions from still having those stances, but what it would do is require them to clearly and openly disclose those decisions and those determinations as part of their process. We believe that this light shine on all of their procedures and policies may lead to some rethinking of those policies moving forward as they put them out for general distribution and consumer review, and the consumer once again becomes more informed and starts to question how and why, especially with the notion of regional versus national accreditation and SARA and distance education and all of these other, once again, modalities, all playing into a more homogeneous world of review of credits and education, why institutions would seek to limit or preclude prior credits from transferring into other institutions. As you can see here, and as you probably are no doubt aware by now, they must provide information on the established criteria, a list of institutions with which they've established articulation agreements, and written criteria that evaluate how credits for prior learning experience, direct assessment, and other issues are all assessed at each institution. Lots of new good information from a consumer perspective that all institutions, including ours, are going to be required to provide to all individuals coming forward. In addition to these, we have descriptions as it relates to a number of areas with regard to, as I alluded to earlier, licensure and certification and the requirements that are required for the certificates, including the name and location, as you can see here, of the organizations that the degrees and certificates are through, the method of delivery for the educational programs and the estimated costs, demographic and outcomes information, again, not something necessarily as new to our community, but certainly new to state colleges and universities, private nonprofits, and other portions of our colleagues in the broader higher education community, as they are now required, as are we, to not only put forward information on placement rates and graduation rates, but on issues such as the number of male and female students, socioeconomic and demographic information, placement rates, retention rates, and other information that, again, from their perspective is relatively new to them and foreign to them, and will probably be interesting to watch as that information starts to come out, and we do a little bit of forensic analysis to make sure that the presentation of that information is forthright and equal to the way in which the regulations have anticipated it be brought forward. And we all look at potentially for the first time some apples to apples and oranges to oranges comparisons of a lot of this information. Health and safety, again, not necessarily new. These type of requirements are things that you had to do and report in the past, but as part of the disclosures, they've been melded to a certain degree and again included to ensure that this type of information is received by the consumer. Also, as it relates to these policies, your refund policy, the policy for complaints, and the ability to share that information in order to allow individuals to not only reach out to your institution, but to give them access and key contacts to seek the ability to provide complaints to accrediting agencies and the state authorizing agencies. And last, but certainly not least on this slide, and second to the last of the things that we'll cover here, a reminder that if in fact your accreditor requires or your state requires a teach-out plan, teach-out agreement, and other processes with regard to teach-outs in order to protect against precipitous closure or any type of transition towards closure of a campus or other types of reductions in the overall education, that there is the information provided and ways in which that information can be obtained. Last but certainly not least, the regulations and the disclosures also call for the publication of an institution of enforcement actions or prosecutions brought against the institution by various different entities, predominantly at the state level. This information is information that, along with the rest, must be provided, and therefore we make sure that we encourage you to ensure that this is something that you always review and update along with the rest of these. Investigations that are not provided have very, very costly fines and other implications associated with them, as do the rest of these disclosures, and we don't want to see you fall out of compliance and fall into harm's way as it relates to the very punitive fiscal as well as potentially administrative burdens that will be placed on you if you fail to do these disclosures. Breaking news, one of the things that we know has had a lot of discussion of late is whether or not these disclosures, all of the new disclosures that I just went through briefly, and again, we encourage you to go back and review these in much greater detail to make sure that you meet all of the requirements and all of the particulars of the regulatory requirements on what I just covered. But one of the questions that has been asked multiple times is that as it relates to audits, that institutions have been granted a 6-month reprieve given the current circumstances of the national pandemic related to COVID, whether or not as part of that 6-month extension that they're given before they have to submit final financials, whether or not the disclosure requirements under these new regulations should be or will be reviewed and should be submitted as part of your submissions post July 1st. In conversations with Department of Ed officials and in furtherance of their suggestions and recommendations to me, until such time as there is the potential of in writing changes that would stipulate that an institution does not need to include that information in submissions post July 1st, the guidance and the recommendation is that you should include it. Now, that does not mean that the department is not strongly looking at the reality of withdrawing that particular notion in the near future and potentially, hopefully, before we attain the 6-month window where that information would need to be required. Their thinking right now is that until they can get actual electronic announcement guidance or interim final regs or other forms of guidance out, and until it's in print, that institutions should be thinking in terms of having to submit that information as part of your delayed submission to the department because you have crossed over the July 1st timeline. Again, I can tell you that is very likely subject to change, but as some of your institutions working with your accountants may be putting forth those submissions shortly after July 1st, given the 6-month window for fiscal year ends last December, that information is questionable for those institutions that have a July 1st year-end and audit cycle that would have 6 months and choose to submit that information maybe on time or maybe sometime between July 1st and the end of December of this year. Long-winded way of saying it's another one of those areas where the guidance will likely change, but until such time as it does, like with so many things, until we have it in writing and until we see the official guidance in the Federal Register or elsewhere stipulating the change, the rule of thumb and the conventional wisdom and guidance is to include it. Title IX, again, a whole brand new set of regulations that were introduced by the Department of Education. It took them over 18 months to cycle through the process of the development, notice of proposed rulemaking, and issuing of final regulations in this area, and then turned around and stated that because entities had been aware of these regulations for so long that there was basically going to be a 90-day window from May to August in order for implementation, and that the new Title IX rules would go into effect on August 14, 2020. Given the level of detail of over 2,000 pages, 2,033 to be exact, of the regulations and the guidance that was included in the preamble and elsewhere, we certainly don't have time to go through those regulations in depth at this particular point in time. What I can tell you is that throughout the month of July, we will be doing additional webinars specifically on Title IX. We will be focusing on it in great detail on August 18th, 19th, and 20th at the CSPEN, and 21st at CSPEN's annual conference in St. Louis that I'll share more information with you on later. But one of the resources that we flagged and believe that is of considerable benefit for you as institutions to review is a May 8, 2020 presentation that was put forth by the Office of Civil Rights at the Department of Education just after the introduction of the new regulations. The front page of that particular hour and 15-minute presentation is listed for you here, along with the URL for the YouTube. Here are the 7 major issues that once again were covered in that particular presentation by the Department of Education's Office of Civil Rights and key individuals within that department. The ones that we would encourage you to spend the most time on, not that all 7 aren't important, are 3 through 6 collectively, which get into a great deal more detail on what the schools must do in support of the alleged victims, as well as the personnel and policies that the schools need to be implementing by August 14th, as well as the other information with regard to the other new features in the regulations and the grievance process and how that all plays out. Questions that we have received related to this regulation and our initial review and subsequent information to be shared with you all is what and to what degree and what level of detail an institution is responsible under the disclosure requirements of Title IX to list and provide information and access points to various individuals like Title IX coordinators, the investigators in the event that you, as part of your processes, policies, and procedures, whom those individuals can contact in order to protect themselves and isolate them, or if they have complaints or concerns with regard to victims' rights versus the accused rights, and so on. All of that, like I said, we will be providing multiple webinars and presentations from other department officials in the not too distant future. But we wanted to remind you because literally we're a month and a few days, a month and a half, literally almost 45 days out from today from the current likely implementation of Title IX based on the regulatory guidance. A major caveat here, as is the case with many other things that we have witnessed in the past, borrower defense to repayment, GE, and others, is that these regulations, while out and published by the department, can have other intervening actions taken to stop or reverse them. We anticipate that the U.S. Department of Education will receive guidance from Congress under the Congressional Review Act to attempt to repeal and overturn these regulations, similar to the way in which they sought to repeal and overturn the borrower defense to repayment regulations. We'll remind you here in just a few minutes of the successful presidential veto of that action taken by Congress, and the reality that even with 7 additional Republicans joining with the original 231 Democrats in the House, that just a little over a week ago, almost a week and a half ago now, the House failed to override the veto on those borrower defense to repayment regulations. We do anticipate them bringing forth a similar bill, a similar resolution, House Joint Resolution and Senate Joint Resolution, attempting to overturn these Title IX regulations. As you'll recall from a number of CSPEN prior webinars, this is an issue that is very much of concern to the Democrats. They believe that the changes with regard to these regulations swing the pendulum too far back from the protections of victims' rights towards more leniency and more latitude towards the accused. The concerns that they have relating to the opportunity for cross-examination of the alleged victim by individuals representing the accused is very much to their disliking, as are a number of other provisions within these final rules that they would like to see overturned, and they believe go 180 degrees from the Obama administration's prior Title IX regulations that they were very happy with. I will share more on one piece of legislation just introduced that focuses on some of that as we get to the legislative update in just a few minutes. But for now, keep that on hold. But remember that Title IX, those regulations are literally less than or right at 45 days away from implementation, unless the Congress takes action and or the courts. And last but not least, the courts are likely to see additional efforts, as was BDR and other rules, to attempt to probably determine whether or not legally they can challenge the implementation of those regulations and potentially have judges ruling in favor of either limited or full repeal or withholding of the implementation of the regulations. Some of that litigation has already been put forward, and we anticipate more to follow. From the regulatory side, with regard to the HERF, Higher Education Emergency Relief Act funds, and where we stand with those particular funds, the department has gotten well over 90% of the student funds out. That does not mean that the institutions have delivered all of those monies to students, but that the department is now in excess probably of closer to 95, 96%, based on a call I had yesterday, of those funds being distributed to the institutions for the institutions to then distribute to students. We all know that there are a number of questions and challenges that remain on which students and how those funds can be dispersed. We've had several back and forths and several whole webinars with CSPEN and with others that address the question of whether or not and which students, DACA students, are or are not eligible. With the publication recently of the final rule, the department has made clear that it is their belief that DACA students are not eligible, and that the only students that are eligible are individuals that either are or could be eligible under Section 484 of the Higher Education Act. Those students that have any prohibitions are not eligible, and if they are attending a Title IV eligible institution, meet some of the other criterion that would prevent or eliminate their eligibility based on other actions or activities, and DACA students are not included. There has been some back and forth on that particular issue because of the department's sub-regulatory guidance in the form of electronic announcements that they put out previously, then backtracked on that with information in May, and then now with their June policy interim final rules have made it clearly definitive where they stand, which was in essence a reaffirmation of where we thought they stood in the beginning. Long-winded way of saying that that's another area where there continues to be dialogue and continued questioning, not unlike with regard to institutional costs and how and in what manner those funds can be utilized. The number is accurate. It's close to 80% of those funds that have been distributed and dispersed to institutions. And like with the student funds, there are a number of institutions across the entire higher education spectrum that are still questioning exactly what they can and cannot utilize those funds for. In an effort to try and clarify that, the Department of Education had a presentation for stakeholders last Tuesday and put forward a webinar with Assistant Secretary for Post-Secondary Education King and other members of the department, where they attempted to try and help clarify what the funds could be, the institutional cost relief funds could or could not be utilized for. Unfortunately, in that effort to try and clarify and bring greater greater familiarity and understanding to those regulations, Assistant Secretary King made some comments specifically around lost revenue that were perplexing, and depending on individuals' interpretations, could have, and many believe did, and provide the opportunity for institutions to utilize portions of their institutional cost relief funds under Section 18004A1 for lost revenue. That is not the case. In further discussions with Department of Education officials and all the way up to the highest levels, it was made clear that the Assistant Secretary did not, in fact, and if you review the transcript and go back and review the information, while the Assistant Secretary may have commingled conversations about lost revenue as it relates under Section 18004 A2 and A3 with A1, the department's interpretation as we sit here today is that lost revenues, other than those specifically prescribed as part of FAQs, are not eligible to be a means at which institutions can utilize those funds to recoup and reimburse themselves for lost revenues. Those areas where they can are specifically things like for the payroll and for other things related to employees that were in the dorms and other things. But in terms of lost revenue, it's very, very prescriptive and very, very limited. We know that many of you listened in on that conversation a week ago today, had questions, researched it, asked your accountants, asked your legal advisors, counseled, including many of whom are part of CSPEN's Attorney Roundtable and others. And while we all heard the confusing remarks, further clarification, and we hope even more clarification that the department will be bringing forward on its own, will unfortunately, but yet definitively state that when it comes to lost revenue, the only areas where lost revenue can truly be utilized from the funds received from the department are for institutions under Title III, 5, and 7. So not necessarily the news you want to hear, but also the news that will keep you in compliance and potentially keep you out of harm's way, because if you were to utilize these funds in inappropriate manners, there will be problems and complications as you do the reporting and and provide the department with the information based on guidance yet to come on what and how they want to see your delineation of how all of those funds were utilized. Which does in fact bring me to coming attractions. We do anticipate that maybe even yet this week, before the July 4th break or shortly thereafter, that the department will be providing additional information, not unlike what they did in terms of fleshing out the reporting requirements for institutions to share with the department on how they expended or are looking to expend with their processes and procedures the student emergency grant assistance under the HERF. Soon you will be getting additional guidance and information on how the department would like you to report how and what you're utilizing the institutional cost portions of the funds for. I can tell you that the department is very much focused on ensuring that the areas clearly articulated in statute that are prohibited are not what you're using the funds for. From our perspective, the one that glaringly sticks out is the whole notion of that no institution can utilize any portion of the funds for pre-enrollment activities with a third-party vendor as it relates to marketing, recruiting, and advertising. It also goes on to articulate and specify that those funds cannot be used for any forms of religious affiliation beyond the benefits of the students, and also for any athletic endeavors or things of that nature. But the one that, again, is most important to us is the pre-enrollment activity prohibition. I don't think, and I believe that it has been clearly stated by all manner of groups, whether it be your accreditors, whether it be state associations, national organizations, vendors in response to that are responsible for financial responsibility criteria, support for your institutions or others. It is very clear in the FAQs and elsewhere that the department will allow you to utilize those funds for things that are as important. You can show a clear nexus to the disruption based on COVID, but as it relates to marketing, recruiting, and advertising, the answer is very simply and unequivocally no. So we look forward to sharing with you that guidance when it comes forward. We are also anticipating yet more information from the Department of Education. They put forth an NPRM and opened up a comment period for more on state authorization, looking at things like direct assessment, as well as prior learning experience and other changes to the regulations that have gone through the NPRM process. And we believe that the department will be putting forth that information sometime certainly between now and November, the deadline under the master calendar. We do believe that there may even be yet another distance education NPRM yet to come out, still going further with regard to a number of these regulations and specifically building off of the work of the consensus-minded negotiations. We still have the two remaining portions of those negotiations that we haven't seen yet, those being religiously affiliated institutions and their requirements, and also information as it relates to teach grants, things not necessarily of as greater relevance to our community as others, to be sure, but things that we're still watching for as they come forward. We also do anticipate more continued FAQs coming out on both sides of the discussions around the CARES Act, meaning by that more information and guidance on how the funds can be utilized with students and also on the institutional side. So a great deal more guidance anticipated from the department. One of the things that I think you've heard from everybody over the last year and certainly over the last 2 to 3 years is that one of the reasons that maybe some of the things within the department have lagged is because they don't have full staffing, and the number of individuals that have been put upon to try and juggle all of these pieces is relatively limited. CSPEN has reported that one of the upper level management positions was posted and about 3 weeks ago now to be fulfilled, as there is some internal shuffling going on within the department. The department also just posted the request for new experienced individuals for 3 mid-level positions within the department that would be, again, those type of individuals that could assist in the development of and through their expertise, hopefully the advancement of these regulatory updates and determinations. So the department and specifically the administration have noted that it is overly burdensome to the individuals within the department is starting to get them help. Not a moment too soon, and certainly probably well past when they could have used that help, but better late than never. So if you have individuals that are of interest, let me know, and I'll share those postings with you. Maybe one of your financial aid directors or financial aid personnel is one of the individuals that we could help put over in the department to continue to help with the cultivation of the development of these regulations as things go forward. Moving forward to the legislative status report, while certainly we have spent a great deal of time as a community focused on 2020 on the regulatory side of the House, we still keep an eye towards the activities of Congress, both good and bad. Certainly the CARES Act, the original CARES Act that was enacted on March 27th, was a movement that showed the benefits of stabilization funds for all students and all communities, including ours, and was the work of all of the participants, state organizations, national organizations, 501c3 nonprofits, sharing the information with you all and with the community as a whole, working towards the ability and the benefits of seeing our institutions and our students treated equitably in such an important piece of legislation. Well, we know that there is the potential for another round of this type of economic stimulus and student as well as institutional institution of higher education driven proposals to be considered in the not too distant future by Congress. In the House, the HEROES Act was already introduced and passed by a vote of 208 to 199 back on May 20th. We at CSPEN and others have shared with you a summary of that STEM 4 or COVID 4, which is kind of the acronym that's being thrown around here in Washington, D.C. for the next stimulus package. It's basically because there was a 3A of CARES, it is the fourth, or if you're counting differently, you could say it was the fifth. Regardless of what you call it, there is a discussion here in Washington, D.C., especially now, as to whether or not with the re-announcement of ramp-ups in several states of COVID-related outbreaks returning to various states and various areas, as to whether or not additional funds are needed and necessary. The House, in their bill, put forth money not only for general economic stimulus, a great deal of money targeted towards the vaccines and further testing for COVID, but also put forth some $26 billion thereabouts for both governor discretion and direct funding to institutions of higher education to continue to try and support safety and furtherance of the delivery of higher education as the pandemic continues. The major problem with the House bill is that in the development and in the proposals contained within this legislation, the for-profit community, our students first and foremost, as well as our institutions, basically need not apply. The funds that are gone, that are $10 billion plus that are given to the governors, are established in such a manner and in a narrow focus where it would be less than likely and highly improbable that our community would see much, if any, of those finances. And in an additional $13 to $16 billion that is prescribed directly to be provided to students and institutions of higher education in the next round of funding that builds off of the language in the prior CARES Act, none of the for-profit community, our students or our institutions, are eligible for those funds. In fact, a little sidebar, it is very interesting that if you look at the devil of the details, when they prescribe what those funds are to be utilized for, the prohibition language that was in the original CARES Act, and specifically that no funds shall be used for pre-enrollment activities by institutions with their third-party vendors for marketing, recruiting, and advertising, has been eliminated. You are certainly not left to wonder, but can see very clearly that the Democrats and others put that language in the prior bill thinking of us, and as soon as they excluded us from the potential for eligibility for those funds, and again, more importantly, our students' eligibility for those funds, because those are the ones that are continuing to be disrupted as this process continues to unfold, should not be eligible to apply. But I guess when it's money going to the state colleges and universities, community colleges, and other traditionals, they can use it for marketing, recruiting, and advertising, and probably anything else in the hell they want, because they're of integrity and we're not. But I digress. Sorry, for the little sidebar there, but it kind of shows you that it's getting to a tipping point in a lot of respects when it comes to the way in which things here in Washington are moving. As you shift over to the Senate side, there is certainly more of an opportunity for equity. The Democrats in the House and the Democrats in the Senate continue to push for these new funding bills and specific amounts of money. ACE, the American Council on Education, says that there is at least a minimum of $46 billion that is needed to continue to support higher education. And again, they focus more predominantly on traditional state colleges and universities, online students and institutions that were ineligible during the CARES Act funding, as we know, and also, again, the focus on full-time equivalents and other students other than our own in the portion of what they requested for the funding. The Senate and their deliberations are focused on a couple of other things and may not even if they move forward with legislation, may not mirror the request of either the HEROES Act or the request of the higher ed community at the broadest level in where they choose to provide additional funding, if they do so at all. The Senate has made it very clear that their primary focus and their one must-have above all others is liability protections for employers, businesses, and it carries through to institutions both at the elementary and secondary and higher education level. When it comes to the potential for any funding for institutions, Senator Alexander, Secretary DeVos, and others have made it very clear that their focus, they believe now, should pivot more directly even than the first HERF funding on funds directly to students. And even more directly, as Senator Alexander made a point to emphasize throughout the two hearings that he and the Senate Health Committee have had on the pandemic and the protection of trying to bring individuals back to both post-secondary as well as elementary and secondary education safely, that the funds, if any, that are provided should be utilized for protections in the name of providing additional access to the test, to establish who and who isn't symptomatic, or whether it be asymptomatic or full-blown with regard to COVID testing, as well as the development of a vaccine and ways in which to utilize the vaccine to protect students on college campuses at the post-secondary level. So you can see that a lot of those discussions are different from giving more money to institutions and having them then determine and distribute and delineate how it is utilized. From a Republican Senate perspective, the focus is more on what can we do to return students to elementary and secondary and post-secondary education safely, and what financing do we need to provide to entities to ensure that the students are protected. For this reason, CSPEN has been having a great deal of conversations with various groups on recommendations of what beyond just PPE is needed and necessary in order to protect and bring our students back safely in our community, and are working to provide and share that information with individuals up on Capitol Hill and elsewhere, and are encouraging our state association colleagues and others to be advocates on behalf of their communities in sharing with us that information, so that we, in potentially a report form or in other forms, can share that information with the department, with the individuals up in Senator Alexander's office, the Republicans on the committee, as well as the Democrats on the committee, so that our students, first and foremost, once again, receive equity as any potential negotiations come forward with any new stimulus funding. Showing that there is, again, a differentiation in this regard. Literally this week, Senator Murray put forward her Coronavirus Child Care and Education Relief Act. This is new legislation that she put forward. The devil of the details of this legislation are something that we will be summarizing and sharing in an email blast, a Tom bomb, in the very near future. And specifically, once again, no surprise to you, as it is coming from the Democratic side of the House, the proposals that are being included here with regard to higher education, unfortunately, limit and prohibit access for our students while expanding it and trying to divert it only to institutions that are within the public domain or the private nonprofit domain. Again, the question becomes, and I think one of the things that we as a community are going to have to continue to make known is that if this is truly about the disruption to students and students' education and student safety, we are stand ready and willing to provide that safety and do all that is necessary on our end, and should equally be capable of receiving the opportunity for the financing to do so. A new wrinkle that has just come about, the House and Senate are starting to prepare for and have been planning for quite some time through negotiations and hearings, even during the pandemic, to start to look at the financing for the next fiscal year. And one of the two major bills that are always the focus are House and Senate of Defense Appropriations and House and Senate labor, HHS, and education appropriations. Well, currently the Senate is preparing for a markup of their defense bill in the next few days, and in review and continuing to monitor the actions of that committee, we are very much concerned, as has been reported by Politico and tracked by ourselves and others, that there are provisions attempting to be included in that appropriations bill that would harm our students and our community. The first of those is a provision, basically we're going to outline 4 of them, 2 of them that are proprietary, specific, and harmful, and 2 that are more generic, but all of which we are tracking. The first 2 that are harmful is an effort by Senator Richard Durbin to put forth a provision that would modify the Higher Education Act, returning the 90-10 rule back to the 85-15 rule, and forcing the inclusion of all forms of military assistance as portion of the 85%, leaving more limited funds to be counted toward the 15%. Another provision that would require, and it's being put forward by Maggie Hassan on the Education Committee, but also on the Appropriations Committee, to maintain a complaint tracking and resolution system within DoD of military funds. It's interesting that this complaint system is only necessary for proprietary institutions and post-secondary vocational institutions, but is not extended and is not requested or required of all of the institutions providing education to our nation's military and all of those individuals' ability to complain if there are problems with any of the education being delivered to them by institutions other than proprietary and post-secondary vocational. 2 amendments that are inclusive of the entire higher ed community are, one is from Mr. Durbin that ensures that online information is provided by the Department of Defense with regard to the current regulatory, civil, and criminal investigations of institutions by state and federal agencies. It's intriguing to us that why, if this is so important, why isn't that same complaint process at the institutional level something that should be the same as whether or not any entity is being reviewed by state organizations or federal agencies? And then also a provision that is being promoted by Sherrod Brown from Ohio is that the use of revenues derived from educational assistance furnished under laws from DoD cannot be used for marketing, recruiting, or advertising. Again, this one is not prescriptive and limited to just private proprietary institutions or post-secondary vocational institutions, but will be a prohibition for all. I would think that one of the things that our community could look to do is query and question why it is that these are good enough for only a portion of our community, very similar to the ways in which our community continues to address the opportunity for Senator Enzi's bill to bring forward the notion that if there is validity to the 85-15 or 90-10 rule, that it should be applied equally to all institutions, and whether or not we can push for the inclusion of that discussion, not only in this kind of backhanded way the Democrats are trying to move forward higher education policy in an appropriations bill, but look to push some of our agenda in that process as well. Why is this so important? Well, because reauthorization of the Higher Education Act is something that is going to be out into the future and not something in a comprehensive fashion that we're going to see prior to the end of this session of Congress. In conversations directly with Senator Alexander's staff, other Republicans, and other Democratic offices over on the Senate side, you know that we have been reporting that there have been bipartisan negotiations ongoing. They cropped up early in the year, kind of waned for a while, cropped back up with the benefits of some of the other bipartisan legislation that Mr. Alexander and Ms. Murray were able to do together, including the CARES Act, but now have waned again and are showing that, again, as we get closer and closer to the election, that partisan politics are coming out in a number of different ways. All of this to say that reauthorization is down that road. probably likely in 2021 and 22, but it does not mean that we are not needing to be steadfast in our direction and in our focus on monitoring what's happening in the defense appropriations, the labor HHS appropriations, and any of these other stimulus acts. Those are must-pass pieces of legislation where it's very apparent to us that both good and bad provisions are going to be floated and attempted to be brought forward in that legislation in an attempt for Senator Alexander to move some of the changes, the simplification of FAFSA and other favorable changes that the community at large, and including a large bipartisan group of senators, would like to see, but also some of the certainly less favorable and certainly draconian in other cases provisions like what Senator Durbin, Senator Murray, and others are trying to slide, and Ms. Hassan and others are trying to slide in to various appropriations bills, and what the HEROES Act attempts to do with regard to the Democrats in the House on exclusion of our community as another means of trying to limit or eliminate our participation. Shifting from that bad news to one more set of good news that, again, we strongly urge you here at CSPEN to focus some of your time and energy on. We know that you have very little of that is not focused on your day-to-day operations, on all of those heady compliance issues that we just discussed, and efforts to advocate on behalf of your students and yourself through Congress and through elsewhere. But we do want to make you aware of some favorable news and some things to hopefully uplift you as we also look at the midpoint of 2020. And that is our continued focus by CSPEN on the American Workforce Policy Advisory Board and a status report on their 6th meeting. As many of you know, CSPEN has been a major advocate of the American Workforce Policy Board since President Trump established that in an executive order many years ago now. We have monitored and reported on the efforts of the Workforce Committee under the supervision of the co-chairs, meaning Ms. Ivanka Trump as a White House advisor and Secretary of Commerce Wilbur Ross, individuals who have been fighting very, very hard to make some major changes and have put together a group of basically what would rival and is not unlike the advisory boards that I know that many of your institutions have in each discipline, as you look to always be focused on meeting the demands and needs of the workforce, what you do the best of anybody. In the most recent of these, one of the things that I saw that we knew was coming, but I couldn't wait to share with you all, is the fact that at the urgence in particular of White House Senior Policy Advisor Ivanka Trump, she urged the Workforce Committee to continue its work on the development of a campaign geared towards the workforce. Even with the pandemic, even with all of the changes that have come about over the last 3 to 4 months, as you can hear if you go and listen to the most recent or even any of the 6 archived meetings, they pushed for the notion that education includes certificate and diploma and basically skilled worker education, and that skill-based education has an equal, if not a greater need to helping meet our demands into the future than degree credentials do. Therefore, they have developed their own webpage, which is just now starting to be launched. That webpage includes an unbelievable amount of resources and information that they shared in brief on the call. And what it also does is, as I said, it has a campaign that focuses on a number of the major forms of vocational and career and technical education that should be the backbone of new advances, both to reskill the individuals that have been displaced as a result of COVID-19, and also even prior to that, the number of individuals that have the opportunity to fulfill and fill the vacancies in our workforce. This is just one of the billboards that they'll be putting forward. I think you get an immediate visceral reaction that is favorable because it is showing, again, the trades and things that are important to our community and that you provide the disciplines for. In the discussions, they talk about cybersecurity and technical education there. They talk specifically about a significant number of grants from IBM and scholarships. Similarly, from Lockheed Martin, as it relates to aviation, as well as auto diesel and a number of others. Here is some of the print advertisements that they're looking to bring forward. I can say to you, we've talked about for many a time, and many of you have challenged CSPEN to try and look towards means and ways to once again promote our industry through campaigns. I assert to you, the federal government and the Department of Commerce and the National Advisory Board are doing it for us, and that with visuals like this and the campaign that they have put forward and the reaction that I hope will come from it, and specifically the focus that is on the types of disciplines and educational programs that you offer, is something that, again, should uplift you and should be a positive as we conclude this webinar here in just a few minutes. With that, I will open it up to a few Q&A. We do have about another 15 minutes, so I did hit my mark to provide about 15 minutes of Q&A. Again, it'll be a little hard for me because I have to review the questions at the same time as I present to you all, but with over 262 of you still on the call, I want to thank you first and foremost for being on the call. And before I get to the Q&A, I will do one more thing, and that is remind you as well that we do have our upcoming sixth annual conference on the 18th through the 21st at the Ritz-Carlton in St. Louis. I am proud to announce that we will, I cannot give you the exact names yet, but I can tell you that we will have individuals represented from the National Advisory, Workforce Advisory, National American Workforce Policy Advisory Board presenting at our conference as a keynote, as well as key individuals from the Department of Education, and an unbelievable lineup of breakout sessions that include members of our community, meaning the institutions, you all that are participants in CSPEN, as well as our vendors, sharing new and innovative concepts and ways in which that we can continue to move forward as a community all together, not only through advocacy, but through a strong utilization of all of the information that we have. With that, I'll turn to some of the questions. For additional disclosures, is it acceptable to have the link to iPad's College Navigator for demographics, retention, and placement info? The short answer to that is no. It's a combination of that information with these actual presentations, that disclosures that you have to have available. One of the things that the regulations are looking for is the high visibility of a lot of this information. So they don't want it buried in the iPad's data and elsewhere. They want it more prominent and prevalent than that. Regarding HERF, does the school have to distribute all student grant funds before it can request the institutional grant assistance? No. What institutions are required to do is that they must have executed the request for the student funds before they can fill out and execute the request for the institutional funds. As I alluded to in one of the earlier slides, most institutions have not only executed, but have received their student grant, emergency grant assistance funds, and in most cases are either have received or are close to receiving their institutional costs relief funds as well. Those portions that can be used for the nexus between the disruption of the pandemic and the ability to retool the information and retool the delivery of education by your institution. If 90 to 95% of the funds have been sent from ED, have institutions to use funds, non-student funding from HERF been sent to all institutions yet? As I said, upwards of 80, and it's actually closer to 85 to 90% of those funds have or are in the process of being delivered by the Department of Education. That's based on conversations with individuals over in the department and the HERF process yesterday. So the department is getting close to having the vast majority of all of the funds either fully delivered or queued up to be delivered in the very near future. I can't tell you that this was a goal, but I can tell you that it was a goal, that they try and have all of these funds out by no later than July 1st or the beginning of that, or very early in the month of July. You'll note my July 4th Independence Day shirt. That was by design. I do believe that it is their goal to have the ability to say that almost all, if not all, of the funds were distributed by no later than the early part of the month of July. Other questions? Hold on. Our CARES Act student funding policy states that only actively currently attending and leave of absence students may request and possibly qualify for the funds. If a student submits the application and graduates before the funds are processed, is this still a compliance? It's compliance with our policy. It sounds like it is. I will follow back up with you in private and also encourage you to talk to your counsel about those type of granular questions. But in general, your policies and procedures, which the department intentionally gave a great deal of latitude to all institutions, set the stage for how you can utilize the vast majority of these funds and how and who are eligible and not eligible, other than the things that I already described, DACA students, those students, those students that are totally online are ineligible. That's one of the things that, again, might be changed in the next iteration of STEM 4 or COVID 4 economic stimulus fundings, because you can make the case, as many have, that there are students that were all totally online that still had disruptions as it relates to the pandemic. Certainly different than room and board and some of the others, but nevertheless that there are problems that individuals that are in an online environment are experiencing and having to deal with and grapple with as well. But I'll get back to the person who requested that information in a separate email. For demographic information disclosures, since they have yet to since they have to be reported in different ways to different organizations, can we just direct students to iPads on the College Navigator? Again, the answer to that, unfortunately, to the best of my understanding, is no. This has to be the separate inclusion of this information, and in many instances is an attempt to try and elevate this information beyond iPads and the way in which the information has been provided before. Which placement and retention rates should we use when we are reporting? Is it different if it's different for the three organizations? Again, there is specific information in the regulations on how and what information you are to provide and how you are to provide it, including a number of stipulations on how prominently it is to be displayed. I encourage you to go back to those regulations, and for individuals that, and several of these questions, what we'll do is I will put together some of this information and we'll share it with the community in a subsequent webinar and also in a subsequent email blast. With that, are there any other questions for the good of the order? If so, go ahead. I'll leave it open for a few more minutes to see if there's anything else that you all have in terms of driving questions at the moment. The last thing that I will say once again is, please do not be surprised if we see some additional information coming out from the department in the not too distant future. Again, that guidance on how to report your institutional funds is one of the next things out of the gate that I think will be coming on the HERF side. We do anticipate more FAQs, like I said, that will give additional guidance. I touched only very briefly on the fact that you will hopefully recall that at the beginning of this month, the department did put out additional FAQ information on R2T4 and SAP. The R2T4 guidance that they put out extended the utilization of the limited return of federal financial aid all the way through to the end of this year under the R2T4 calculation. You'll recall that previously it was limited to a much smaller period of enrollment and time frame. The department have now, because of the continuation of the pandemic and the anticipation of not only open enrollment institutions, but students and institutions returning either in hybrid fashion, online fashion, or bricks and mortar fashion to education in the fall, that the pandemic and again these rises of potentially new outbreaks, significant outbreaks, to provide some of the R2T4 funds safety precautions going forward. Department of Education announced a second tranche of funding for Section A3 of the CARES Act. These funds are intended to reimburse schools that demonstrate significant unmet needs related to the expenses. Do we need to get approval from institutional portions before we request this portion? Unfortunately, you are not eligible for those funds. The funds that are provided under that additional portion are for institutions that are eligible participants in Title III, 5, and 7, which our institutions in our community are not. So while those funds are in fact accurate, and it is accurate that additional funds were provided under that portion of the CARES Act, we are not eligible for those. There are other forms of funds that were included in the additional 3A portion that came under the Department of Labor that you are eligible for, and we'll be sharing more information on that in the not too distant future as well. With that, and seeing as how we're coming right up on the hour, we want to thank all of you for once again participating in today's webinar. Again, we will have several more coming up in the month of July and August, focused yet again on compliance with the regulations, the disclosures as we learn more, and also the HERF issues as we hear more, and any reporting on changes as it relates to congressional activity. We also remind you that if you have questions or need help in supporting your advocacy efforts, CSPEN always stands ready and willing to provide you with that support. While we cannot directly advocate, we are timely, accurate, and sourceable information that you can utilize to do that for yourself and with your community and under the auspices of your state organizations and other national and regional associations. Have a great day. We look forward to sharing more information with you in the coming months. And most importantly, we look forward to seeing many, many of you with us in August in St. Louis. Have a great day, and we'll see you soon. And last but certainly not least, happy Independence Day. Everybody stay safe, stay well, and enjoy your holiday.